Hello, my name's Osha. I like to talk about American presidents, and today I'm going to be discussing the landmark case Plessy versus Ferguson. This is in continuation of my video series in honor of Black History Month. Today is February the 14th, 2026. Um, so there's a lot to unpack in this case, Plessy versus Ferguson. In my previous videos, which I've titled "What Nigerians Owe Black Americans," I'd gotten up to six. I had already passed the Reconstruction era, and I had reached where uh, there was a Supreme Court decision in 1883, which basically abrogated many of the Reconstruction era acts. So, the case of Plessy versus Ferguson is a landmark decision in U.S. history because it was a proxy um, for the court. The court was basically green lighting um, racial segregation and saying that despite the 14th Amendment and the abolition of the 13th Amendment, the 14th Amendment had equal protection and was saying, well, blacks and whites were equal before the laws. The Plessy versus Ferguson Supreme Court decision would would sanction and become impetus for subsequent segregation laws that reduce Black Americans to second class status and strip them of their civil rights and even voting rights. And it disenfranchised Black Americans in the South again. And even it went it these the segregation laws were now created in other parts of North America as well. So Plessy versus Ferguson, its origins was in Louisiana, in New Orleans, in Louisiana. The plaintiff was Homer Plessy. Homer Plessy was a Black American, and I think I'm going to have to get into some definitions regarding race. So, although Homer Plessy was Black American, he was also something called octoroon, meaning he was one-eighth Black. But during the era of slavery and from anti-miscegenation laws, there were all sorts of categorizations that were created. They were not scientific, they were arbitrary, just to keep blacks subordinate, right? I've talked about anti-miscegenation laws that first started in Maryland in the 17th century and then in Virginia, and then it became entrenched in the rest of the South, which prevented the intermarriage between blacks and whites. And it was intended to work with other laws that kept blacks as slaves, right? Um, so there was something called the one drop rule, right? The one drop rule meant that any person who had uh, an ancestor, a black ancestor, was categorized as black as well, right? And so that was for the purposes of slavery back then. And so an octoroon was one-eighth black, right? Seven-eighth white, one-eighth black. But under American laws, it's hypodescent laws. Hypodescent means that hypodescent means it's a doctrine where sort of a social doctrine where um, people of mixed race, people born of a mixed race union, assume that's a progeny of a mixed race, assume the status, the legal status of the subordinate race, right? And so, for instance, the way it's done in America, just to keep it simple, so I don't go into something tediously academic. If a black and white person marry, of course, we know because of slavery and in the social structure, the racial structure in America, it was blacks that were once held as slaves. In hypo descent, black and white marry a mixed race child cannot claim to be white. The mixed race child is called black. That's hypo descent rule. So there's a racial hierarchy, a social or economic and racial hierarchy that's presumed or that's structured in the system of hypo descent doctrine. So, for instance, Barack Obama, even though he's born to a white mother and a black father, he's considered black. That's based on the doctrine of hypodescent. So, and that's basically the one drop rule. Even though the one drop rule had been abolished, right, with the abolition of slavery and things like that. But in New Orleans, I've done a video explaining how New Orleans, Louisiana, um, was became part of America. It was originally established as a penal colony in 1719 by France, and it was acquired by America through the Louisiana Purchase. So there were a lot of mixed people in New Orleans, and they had a different culture. So Homer Plessy was an octoroon in America. He was identified as legally black, even though he could pass for a white person. But so far, because people already knew on the records that he had an ancestor who was black, he was considered legally black, not white, even though he was light skinned, fair skinned. So there was a law that was passed called uh, the um, uh, Separate Car Act of 1890 in by Louisiana legislature, and it required the segregation of cars. That's separate accommodations for blacks and whites. So the black people of Louisiana wanted to challenge those laws. Again, Homer Plessy was an octoroon, and so there was a group called the Creole of Color, Creole of Color in Louisiana, in New Orleans. And again, these were people who were mixed race, right? But remember, I guess one of the things that also helped the advancement of the black activism, right, that overturned many of the segregation laws and racist laws was the fact that America had this hypo descent culture, right, that stigmatized anybody born of a mixed race, right, that they automatically took the subordinate class. So a mixed race person could not identify as white. And so everybody was just, everybody who was mixed was just categorized as black or a subordinate um, racial caste or and given a subordinate social status. So there was this committee of mixed race people and blacks in New Orleans called the Committee of Citizens, and they decided to challenge this separate car act, which was racist or segregationist. And so they got Homer Plessy, who was again, as I said, octoroon. He was a shoemaker. They got him to stage um, a resistance, right, a defiance of that separate car act, and he bought a ticket, a first class ticket, and went to sit in the whites only car, right? So there was a whites only car, there was a blacks only car on the railways. So he was asked to move and he refused to move. Now, the Committee of Citizens had actually planned ahead and gotten a private detective who had arrest powers to arrest Homer Plessy, right, and have him charged with violating the Separate Car Act and not for some other law like vagrancy or trespassing. They wanted him to be arrested for violating specifically the Separate Car Act because they wanted to be able to challenge it in court that it was unconstitutional. And so he was charged with that and he went to the court to trial. And the judge was a guy called John Howard Ferguson. John Howard Ferguson, interestingly, was originally from Massachusetts. That's where his family was established, but he'd moved to New Orleans and he'd established himself as a lawyer and then eventually became a judge. He'd actually been in the legislature in in Louisiana as well. So he became a judge. It went before him. Now, although previously, in another case, this judge, John Howard Ferguson, right, he had ruled that the Separate Car Act was unconstitutional if the railways were traveling interstate, that it would be deemed unconstitutional in violation of the 14th Amendment Equal Protection Act, right? Because, this law was, it was separating blacks and whites, keeping them in separate cars, right? And remember, the 14th Amendment, apart from the due process clause, let me just remind us of what the 14th Amendment is. It has several sections in it. It's about 5 sections, but I'm talking about the last clauses of the first section, right? Due process of the law. No state shall deny any person the due process. The due process. Sorry, no state shall deny any person, shall deprive any person of life, liberty, or property without due process of the law, and nor shall it deny any person within its jurisdiction the equal protection of the laws. So this was, and earlier on again in the 14th Amendment, there's an early part of it that's talking about that the rights, privileges of citizens shall not be abridged, right? That no state shall make any law or enforce any law that abridges the rights and privileges of U.S. citizens, right? And remember, the 14th Amendment had established that anybody born in the United States was an American citizen, and it talked about naturalized citizens as well. So, it had overturned um, the dreadful Dred Scott decision of 1857, right? So, um, so, so while in an earlier decision, Judge John Howard Ferguson had uh, considered the Separate Car Act of Louisiana as unconstitutional if the trains were traveling interstate, right? That it would violate the Equal Protection Clause of the 14th Amendment. However, in this particular case before him, that's Plessy, right? The case of Homer Plessy, he found it to be constitutional and that Homer Plessy had violated the law because he thought that, well, so long as it's intrastate, that states had the right to enforce laws, that the 14th Amendment did not prevent states from uh, uh, creating, that it was reasonable for states to create their own laws, and so that they had the authority to create their laws, and they had police power that had to do, police power to be able to legislate and create laws that affected health, public safety, and morals. That this was within the purview of the state, and that the 14th Amendment did not infringe that, right? So Homer Plessy, they had filed a writ of prohibitions, right, initially to stop, the trial from going on. Then and then when the judge ruled that the Superior Court denied it, and then when there was a ruling against him, um, it now, well, this video is getting long. I'm going to do another video to just describe the case history, because there are some things I want to get to. But in any event, it went on appeal all the way to the Supreme Court. The Supreme Court again uh, found him to have violated the Constitution, that it was constitutional, that the Separate Car Act was constitutional, and it was in violation. So it went all the way to the Supreme Court. Now, interestingly, the Supreme Court again ruled against Plessy. So the case became Plessy versus Ferguson. Of course, Ferguson being the judge and Homer Plessy being the plaintiff, who was the octoroon. He was a black man, 1/8 black, and he and the committee of citizens had staged this defiance in order to challenge the the constitutionality of the Separate Car Act that was segregating blacks and whites. So their argument when it reached the Supreme Court was that it violated the 13th Amendment because it came with an implication that blacks were inferior to whites by keeping them separate on the cars, right? By requiring them to ride separately on the cars, and it came with a presumption that blacks were inferior to whites, were subordinate. That's one. And then also that it violated the 14th Amendment, equal protection of the laws, right? So, however, the Supreme Court, the majority of the Supreme Court, 7-1, ruled against Homer Plessy. Chief Justice Billings had written the opinion. Importantly, one person was in dissent, and that's who I want to talk about because he had a very interesting life. Justice John Marshall Harlan had been in the dissent, and there were very significant things that he said. He predicted that the case would be that the Plessy versus Ferguson decision would become as infamous as the Dred Scott decision of 1857, and it would eventually be overturned, right? And of course, we know by 18, it took about almost 70 years, though. It took almost 60 years for it to be overturned through Brown versus Board, de facto overruled in Brown versus Board, which said separate but was not equal. So Brown versus Plessy versus Ferguson established that the fact that the that blacks a law kept black people separate, it didn't mean that they were not equal, right? So it was saying, so it established separate but equal, and it became the impetus for subsequent Jim Crow laws all over the South. And so you see parallel systems were developed in the South. So they created segregated schools, they created segregated hotels, businesses, segregated restaurants, segregated bathrooms, restrooms, water fountains, and things like that. So it created a parallel system in the South, which of course was very costly. And many people uh, have argued that it was the exorbitant expense of creating parallel systems that eventually also led to the collapse of segregation and Jim Crow in the South. Um, so the activism of Black people is very commendable, right? That they remained activists and they put their lives at risk. Now, something I wanted to talk about. So the decision of the court was that look, um, the majority, which said that the Separate Act, Car Act, was constitutional, was say argued that first of all, it didn't violate the 13th Amendment. And they said the fact that they created two separate systems or two separate accommodations for the races did not inherently infer inferiority, right? And it also, and the fact that uh, and also that they were that they argued in some circuitous way that by keeping them separate actually allowed for equality, that the equality before the laws was a fact. But they were arguing that there was no way that uh, the racial prejudice that the Plessy lawyers were saying uh, was perpetuated through the segregation laws. They the justices said, well, it wasn't the law that created the racial prejudice, right? That racial prejudice already existed, and that there's no law that can eliminate the racial distinctions, right? They can't legislate. America can't legislate itself out of racial prejudice, that it's already there, but that equality before the laws is a fact, and this was what they were arguing. Um, but however, Justice John Marshall Harlan, though he was the only person in the dissent, right? He was the only person in the dissent. So it was 7-1. Okay. So he argued, he said, well, the other justices were being willfully ignorant. This is what he accused them of, that they were willfully ignorant because everybody understands that everybody in America understood that the separate act, separate, the separate car act was created not to keep whites away from black cars, but to keep blacks out of white cars because that whites, there's a presumption in America that whites were dominant, were the dominant culture, they were dominant in education, in intellect, and wealth, and they were the dominant group. And so that for the justices to pretend that, well, that each person was staying away from the other, that it showed equality. So he said that that was being disingenuous, being willfully ignorant. That's one. He also, so he also argued that um, uh, I think before I state that, let me mention something about his background, and that will help us understand why uh, John Marshall thought in this way. Sorry, John Marshall Harlan. By the way, Justice John Marshall Harlan, who was named after our longest serving Chief Justice John Marshall, right? Chief Justice John Marshall, who'd been, by the way, a cousin of Thomas Jefferson, our third president, but they hated each other. So Chief Justice John Marshall, our longest serving Chief Justice, I think for about 34 years. He's the one who, don't quote me on that, but over 30 years, he's the longest serving Chief Justice. He's the one who was in the famous Madison versus Marbury and other landmark cases. Madison versus Marbury established the power of the courts for judicial review, right? The court's judicial review powers, right? Um, so, in judicial review, that's just the ability of the court to review the acts of the executive and the legislature and see if they're constitutional or not, right? Um, so Justice John Marshall was born in Kentucky, and he was born to a slaveholding, long established slaveholding family. He came from Kentucky, um, and it was a long established slaveholding family. Interestingly, his father, he had a brother, a half brother who had been born a slave, right? He had a half brother who was born a slave. His name was Robert Harlan. He was born a slave, but he was raised by their father with the brothers, but he still had slave status. Um, they moved to Ohio, and at some point, the father, Justice John Marshall Harlan's father, had been Secretary of State, or was it of Kentucky or Ohio, one of those states. Um, and so he had tried to get his son, his slave son, um, enrolled. He had tried to get him educated, but remember, slaves were prohibited from getting an education. So he was enrolled briefly to Robert Harlan, who was mixed race, and he was a slave, and was a half older brother of Justice John Marshall Harlan. When an official of the school, found out that he was actually black, they got him, they unenrolled him, they kicked him out. So, but however, Robert Harlan would get educated through his brothers, right? By studying his brothers' books, because he was close with it. They were close because the father raised them in the same household. He was a slave, he owned slaves, but he raised Robert Harlan. He took responsibility for Robert Harlan, and so he was close to the white brothers. Now, what is interesting about Robert Harlan is that he went on. Eventually, the father freed him legally, right? That's Justice John Harlan's father freed him legally went to court and filed legal papers to set him free when he was already an adult, right? But and then he moved in 1849. He was part of the California Gold Rush. When the 49ers have their name from that 1849 gold rush in California, and so he moved there and he actually made it big. He struck gold. He became wealthy and prosperous. Established several stores in California, and he became wealthy, very prosperous. He made about $50,000 back then in 1849. 1849, $50,000. That's about over $2 million in today's money. So he became very prosperous. He became richer than the rest of his family. His father was a public servant. He was Secretary of State, but uh, Robert Harlan became so prosperous, he started to financially support his white brothers, right? He financially supported his white brothers. So even though Robert Harlan was black, he was considered black, because, again, remember the rule of partus sequitur ventrum, which meant that um, the child of an enslaved woman is also a slave. So his mother was slave of the father, but he the father had tried to treat him well, like his no, no, not a, I mean, the law was the law back then, so the father couldn't claim him legally as his son, but the father set him free, and he went to California during the gold rush, and he became prosperous. He struck gold. He made $50,000, which is $2 million in today, and he started to financially support his brothers. So Robert Harlan eventually actually he due to strong racial prejudice, even though he was now rich, he was a rich man. Um, he tried to go back to Ohio, but because of racial prejudice in America, he eventually moved to England. So he moved to England, got into betting, horse betting on the horse races. And then, he continued to be very prosperous. He invested in securities and started to make about at least $7,000 a year in income from his investments in securities and bonds. So he was a very wealthy man. He lived in England, but decided to eventually come back to America. And he became a Republican. And he became one of those um, black people that benefited from the patronage system and the spoil system after, in the Republican Party after the Civil War. And he at one point was a not a congressman, but was a member of the Ohio House of Representatives. So he was particularly influential in supporting the black community. He was he was an activist for the black community. He tried to pass anti-lynching laws. He was a strong advocate to desegregate schools because of his own experience. And of course, eventually he was actually hired by one of the presidents, I think. Um, he was hired in the Treasury Department as an inspector in the U.S. Treasury Department. So he got one of those plum um, federal jobs, federal appointments. So he was a prosperous person, and even his son Robert Harlan Jr. Remained prosperous. He rose to the rank of colonel in the U.S. Army. So um, the reason why I'm giving this backstory, was to help establish, provide a lens for the understanding of John Marshall Harlan's thinking. Right, he had a half brother who was a slave, but he was very successful, more successful than the rest of the brothers. He became prosperous despite racism, and so he would, our laws were not separated from justices, judges. They're not separated from their experience, right? How society, what they see in society, their own personal experience, their households, and things like that. So you can see how his personal experience, his family, affected the way he saw um, a racist and a segregationist law. because he knew that he had a a half brother who had been a slave, and despite his status, inferior status in the law, he was the one who became the most prosperous, right, of in the family, became wealthy, and he was actually financially supporting his brothers, and that's Robert Harlan. And so, just in his opinion, in his dissent, Justice John Marshall Harlan, he predicted that the Plessy versus Ferguson law decision would become infamous and would be eventually overruled. It would become as infamous as the Dred Scott decision, and which it did, right? And he cautioned that, well, he argued that the U.S. Constitution is colorblind. That was the important thing. He said the U.S. Constitution is colorblind and does not regard classes of citizens. It doesn't regard classes of citizens. And he did say that, well, the reason these segregation list laws were created was because it is implied it is to keep blacks subordinate. That's the purpose of those laws. The purpose is to keep blacks subordinate to white people, right? And he gave as evidence of this in the fact that that separate car act, right, even though it required blacks and whites not to ride in the same cars, to have separate cars, it gave an exception. The exception when a black person can ride in a white car is when uh, it's a black woman who's a nanny working, nursing the children of white people, right? Or a domestic. So he gave an example to show that this is the separate but equal cars, right, was about the subordination of black people, because the only time blacks were allowed to ride in the cars of white people was when they were riding as subordinates, right? Domestic servants, or nursing nannies of, there were wet nurses. Black people were used as wet nurses for white people, then rich white people. So a nursing mother who had had children, she had milk in her breasts, she would use her breast milk to nurse, to feed um, white children. So that's a nursing black woman. That's what the car allowed. If a black servant was nursing, was riding as a nanny and nursing the children of white people, they were allowed to ride in the whites only car. So he said that was an indication of uh, the uh, the subjugate, the intent, the purpose of that law, the segregationist law, Separate Car Act, that it was intended to subordinate black people, right? And it did deprive them of their equal protection of the laws, and so. But in any event, it was the majority said, well, it was constitutional that the states had police power to create laws, that were reasonable within their states to enforce uh, uh, and legislate laws on health, public safety, and um, morals, right? And we see these are laws that are still in effect in many parts of the South, right? Because, as they say, Plessy versus Ferguson, the ideas were not completely overruled, and we see it still happening. So the emergency laws, for instance, in Maryland, I've talked about how 40 cops raided me in my home. It was based on the pretext of a public safety law, right? And so these laws allow proxy uh, racist enforcement by the laws. So there's de jure. There's de jure. De jure means by right, by law. It allows the states to enforce racism, right? These ideas, even though Plessy versus Ferguson, again, it's not really been completely overruled. Well, because Brown versus Board was supposed to have overruled it, and of course the anti-discrimination laws. but we see there's still vestiges of those ideas from Plessy versus Ferguson. I want to keep this video short. I'm going to continue and just explain further. So I'll make it in two parts because it's packed with a lot. My name is Osha. I'll keep you posted. Thank you.